Major breaking news out of the state of Missouri. A huge federal lawsuit has just been filed by several Second Amendment organizations challenging the National Firearms Act. That's right, this is a huge deal, folks, challenging whether or not the registration and related requirements associated with suppressors, short barrel rifles, and short barrel shotguns under the NFA, whether or not that's constitutional under Article 1 of the Constitution and or under the Second Amendment. Let's break it down. Hey folks, I'm Mark Smith, host of the 4-Box Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, before we get into this discussion of this huge lawsuit out there in Missouri, challenging the National Firearms Act, I want to remind you all that next week, I'll be at the Gun Owners of America's Goals Conference down there in Knoxville, Tennessee. A lot of other great Second Amendment people will be there as well. I'll be doing a book signing and giving a speech. So make sure you stop on by Knoxville, Tennessee, if you're down there in that great state next week. And I'll be there along with a lot of your other YouTube friends. Okay, folks, so here's the story. Huge lawsuit has just been filed by the National Rifle Association, the Second Amendment Foundation, the Firearms Policy Coalition, and the American Suppressor Association, among others, challenging the ATF and federal law dealing with the National Firearms Act. As you may recall, since the 1930s, the National Firearms Act is a big taxation scheme that applies to machine guns, short barrel rifles, short barrel shotguns, suppressors, and the like. But thanks to Donald Trump, John Thune in the Senate, and Mike Johnson in the House, the one big beautiful bill was just enacted. And as a result of that, the taxation requirement applied to suppressors, short barrel rifles, and short barrel shotguns was removed. That $200 tax that has been on the books since the 1930s with respect to any transfer of those items has gone vamoose, goodbye, gone, no longer with us, thank God. But that's a big problem, as we've talked about on this channel before. And this complaint there by the NRA, Second Amendment Foundation, Firearms Policy Coalition, American Suppressor Association, among others, makes this exact point. That now that the taxation associated with those items has gone bye-bye, there is no more legal or constitutional hook to justify the registration of these items, the invasion of privacy of gun owner information, the fingerprinting, and all that. Because as you may recall, Congress is a government of what's known as enumerated powers. It doesn't have unlimited powers to do anything it wants. It only has the legal authority to act under Article 1 of the Constitution if those powers are set forth in that article. Jog your memory, Article 1 of the U.S. Constitution deals with Congress and congressional powers. Article 2 of the Constitution sets forth the powers and the responsibilities of the President of the United States. Article 3 creates the Supreme Court and the lower courts and outlines their authority and jurisdiction. But in this particular lawsuit involving the National Firearms Act, they're laser focused on Article 1, dealing with congressional powers. And there's one particular set of powers that Congress has that arguably would justify the existence of the National Firearms Act. And that is the power to lay taxes, to impose taxes. And since the 1930s, the Supreme Court of the United States, among other courts, has said that the National Firearms Act is indeed constitutional because it is a taxation scheme. Congress has the Article 1 authority to tax. The NFA is a taxation scheme, and therefore it's constitutional. But here's the thing. The purpose of the registration, the fingerprint, and all those other onerous requirements that invade the privacy of gun owners to acquire or to transfer an NFA item. What is the legal basis for them to exist under the law, under the Constitution? And the only legal basis for those to exist is one, is that those items, those requirements exist to supplement, to support, to ensure the payment of the tax. In other words, it is a mechanism set in place to ensure the payment of the tax that Congress is allowed to charge under Article 1 of the U.S. Constitution. But now, thanks to the Donald Trump One Big Beautiful Bill removing the tax on those items, guess what? The mechanism to enforce that tax is no longer legally valid. At least that's the theory being advanced in this case of Chris Brown versus the ATF. And that's the first theory. that the NFA is unconstitutional because the Article 1 hook that allowed it to exist in the first place as applied to these particular NFA items, that hook is gone. And therefore the NFA cannot legally apply and require these obligations on the part of gun owners any further. Here's what the complaint has to say to start. The National Firearms Act of 1934 established a $200 tax on, among other things, the making and transfer of certain classes of firearms, as well as a comprehensive registration regime meant to facilitate enforcement of the tax. The NFA and its implementing regulations require an individual seeking to make, transfer, or receive those firearms to provide information such as name, home address, photograph, date of birth, demographic information, fingerprints, and a detailed description of the firearms, including their quantity and physical location. Congress passed the NFA explicitly premised on its enumerated power to lay and collect taxes, and the United States Supreme Court upheld provisions of the NFA on that basis, holding that the NFA was only a taxing measure and that the registration provisions were obviously supportable as an aid of a revenue purpose. Indeed, the Supreme Court has described the NFA as an interrelated statutory system for the taxation of certain classes of firearms. And that's a great setup. And guess what? Thanks to Donald Trump's one big beautiful bill, that hook has gone bye-bye. And that is exactly the point this powerful complaint makes in the federal district court there in Missouri. Here's what it says next. The One Big Beautiful Bill Act, signed into law by the President on July 4, 2025, eliminated the making and transfer taxes on suppressors, short-barrel rifles, short-barrel shotguns, and NFA-defined any other weapons, while leaving the registration requirements intact. In other words, individuals no longer have to pay taxes for making and transferring most firearms under the NFA, but the firearms are still required to be registered and are subject to the web of regulation that was designed to aid enforcement of the NFA's now extinct tax. This regulatory regime no longer comports with Congress's constitutionally enumerated powers. While the NFA's regulations may have been permissible in support of the statute's taxes on making and transferring firearms, that justification no longer remains for the items whose making and transfer are no longer taxed. To the extent that the NFA imposes requirements on making, transferring, receiving, possessing, or otherwise using untaxed firearms, it cannot be justified as an exercise of any other Article 1 power. Accordingly, the NFA is unconstitutional as to those untaxed firearms. Powerful stuff, and that's clearly correct. We've covered this on this channel before. We also know that the Gun Owners of America have a powerful lawsuit down there in the state of Texas. This is like a sister lawsuit now brought by other Second Amendment organizations. They're all attacking in the same way, and I think that's fantastic. And I think they should win because, again, without the taxation hook, all these other nonsensical registration requirements are simply not allowed. And by the way, as a side note, it's my view that the parliamentarian in the U.S. Senate totally screwed this up and got this entirely wrong as a matter of constitutional law by refusing to allow the Senate to pull out all these items entirely from the NFA. And I remain cautiously optimistic that regardless of where these lawsuits go, next year in 2026, I still think we have a legitimate chance in the process of reconciliation to have the parliamentarian change her tune and understand what's really going on here. I'm cautiously optimistic that if these lawsuits don't succeed, and they should succeed, I'm still cautiously optimistic that we can pull these items entirely out of the NFA through the legislative process in Congress in 2026, because there's will be an opportunity for another reconciliation bill between now and the 2026 midterms. But I digress. Now, in addition to this theory here in this lawsuit of Chris Brown versus the ATF dealing with the NFA being unconstitutional, there's kind of a second approach here, a very powerful argument under the Second Amendment itself. Specifically what they argue, and it's correctly so, that suppressors, short-barrel rifles, and short-barrel shotguns are all arms under the plain text of the Second Amendment, which reads, of course, the right of the people to keep and bear arms shall not be infringed. The definition of arms is anything that can be used offensively or defensively. That obviously includes firearms because short-barrel rifles and short-barrel shotguns are obviously firearms, so they are textually arms. Likewise, we've talked about suppressors in the context of the United States versus Peterson case down there in the Fifth Circuit, which I've written about extensively, including, believe it or not, in Bloomberg Law, explaining how the Fifth Circuit totally screwed up that and how suppressors are indeed protected arms under the Second Amendment. But as you know, if you ban suppressors, if you regulate suppressors, if you tax suppressors, what have you done? You have banned, you've regulated, or you've taxed a class of firearms, i.e. firearms capable of firing suppressed rounds. So again, when you restrict suppressors, you are restricting a type of firearms that are capable of firing suppressed rounds with suppressors attached, of course. But beyond that, obviously, we know from the U.S. Supreme Court decision in Disarmed versus Brink, it specifically says that instruments that facilitate armed self-defense are protected arms. And obviously, we know that suppressors facilitate armed self-defense, and suppressors being physical objects are by definition instruments. So they're instruments that facilitate armed self-defense, and Bruen says those are indeed textually arms under the text of the Second Amendment. So with that said, once you have a restriction, regulation, or tax on arms, in the case of suppressors, short barrel rifles, and short barrel shotguns, the burden shifts to the government to justify the modern day gun control law. And what is the modern day gun control law here? You know what it is. It is a registration of these items. It is fingerprinting. It is all this sort of nonsensical invasion of privacy by the federal government against gun owners. And the question is there a historical tradition of firearms regulation analogous to this kind of restrictive regime on protected arms under the Second Amendment that goes back to 1791? And the answer is undeniably no. Why do we say that? Well, don't trust Mark Smith and the Four Boxes Diner, although you should, obviously. Let's trust an even better source than the Four Boxes Diner, and that is current Supreme Court Justice Brett Kavanaugh. You see, in the year of our Lord 2011, Brett Kavanaugh was a judge on the U.S. Court of Appeals for the D.C. Circuit in a case called Heller 2, which dealt with whether or not D.C.'s AR-15 ban and also registration requirement on various firearms, whether or not that was constitutional. And but then Judge Brett Kavanaugh was on the D.C. Court of Appeals. He dissented in that case in a 2-1 decision. The majority said that you could indeed ban AR-15s and you could register firearms. It was Judge Brett Kavanaugh, now Justice Brett Kavanaugh, that dissented from that decision and says there is no way on earth you can ban AR-15s. They're in common use by Americans. They cannot be banned. Furthermore, there is no historical tradition of registration of gun owners or guns. That did not exist until the 20th century, and that is way too late in time to be relevant to understand the scope of the Second Amendment. Sound familiar? Yes, and that was Judge Brett Kavanaugh in 2011, years over a decade before Disarmed versus Brink. So Judge Brett Kavanaugh in part got on the U.S. Supreme Court because of that powerful dissent he wrote in Heller 2, and that is clearly the case. And I think that, again, my prediction is in the next 24 months, there will be an AR-15 ban case before the U.S. Supreme Court, and it would not shock me to see the majority opinion written by Justice Brett Kavanaugh declaring that AR-15 bans are unconstitutional under the Second Amendment, bringing back all of his arguments that he used over a decade ago in 2011 in the Heller 2 case when he was a judge on the D.C. Circuit. But with that said, the bottom line here is these arguments are being advanced that the restrictions under the NFA on suppressors, short barrel rifles, and short barrel shotguns do indeed violate the Second Amendment, in addition to Congress not having the authority to do any of this because they lack Article 1. So you really have two separate constitutional theories here. The first is that Congress lacks the Article 1 power to do any of this, and that is an independent basis for all of these laws as applied to these particular NFA items to go bye-bye. That is the correct answer, undeniably, because there's no more tax on this, and because there's no more tax on them, guess what? The mechanism to enforce the tax becomes moot and irrelevant, and thus there's no more authority to act in that way by Congress. And that is a good theory, and I think a prevailing one, so we'll see what happens. Of course, the alternative theory here is that even assuming that Article 1 applies and Congress has that Article 1 authority in some way to do what they're doing here, the reality is this is a violation of the Second Amendment as set forth by none other than Judge Brett Kavanaugh in 2011 in the Heller 2 case. And that lays it all out just beautifully because, again, all these items being regulated are indeed arms. They're all in common use. None of them are dangerous and unusual, and the government bears the burden to show all of this is the case, and they simply are not going to be able to do this. So we should prevail on the Second Amendment claim, even though I think that's really an alternative argument to the main obvious victory or path to victory, in my opinion, which is that the Congress lacks Article 1 to register these guns, since there's no more taxation associated with these items. Anyway, we'll keep you informed as to how this Chris Brown versus ATF goes. Congratulations to all those plaintiffs that brought this lawsuit, including those excellent Second Amendment groups. And again, I hope you enjoyed today's episode dealing with the NFA and this lawsuit out of Missouri. Make sure you follow me on X at @4boxadiner. Don't forget to subscribe both to YouTube and to Rumble, and I look forward to talking to all of you real soon here at the Four Boxes Diner.
Orders up. Table 2A.